Hey, all persons having anything to do with the Honorable Justice of the Appeals Court, now sitting in the bar on with the Commonwealth. Draw near, give your attendance, and you shall be heard. President Commonwealth of Massachusetts, this court is now open. Please be seated.
Good morning. Good morning and welcome to the Appeals Court. I'm Justice Peter Sachs. To my right is Justice Robert Brennan. To my left, Justice Andrew D'Angelo will be your panel for 5 of the cases this morning. We'll have a slight panel change before the 6th case. As you know, if you've been to the Appeals Court before, each side gets 15 minutes to argue. There's no rebuttal. We have read your briefs. We've read at least the most relevant parts of the record. We know the facts. We know the procedural background. We know what the issues are. So we would urge you to get right to your argument because 15 minutes goes by quickly. With that, I will call the first case, which is number 22P833, Commonwealth versus HOLDENS, Roberson. And it's Mr. Murphy?
Yes.
Good morning, Your Honors. Owen Murphy for Mr. HOLDENS, Roberson. Now, I think this case is in some ways very simple. Now, Mr. Roberson invoked his right to counsel about 6 times. He invoked his right to silence. There was no acknowledgement in any way by the police of those invocations, and Mr. Roberson was then placed into a cell. The police in this case were investigating an OUI, and they should have known, reasonably known, that their words and actions were likely to produce evidence of intoxication.
So if there was a Miranda violation, why should anything get suppressed except for the portion where the defendant says yes and puts his thumbs up when asked if he had any alcohol today?
Okay, there are...
Why is anything else the fruit of that poisonous tree?
Because Mr. Roberson invoked his right to counsel, at that point, questioning should have ceased. I understand that there is an exception to booking questions. However, there's an exception to that exception as well. And that exception says that when the police know that they're going to elicit incriminating evidence.
Sure, but wasn't the only incriminating thing, yes, I had something to drink today? Why should anything else get suppressed? How he looked, how he acted. Is there anything else he said that's incriminating?
Yeah, I would say that, again, this whole exchange between the police and Mr. Roberson functioned really as a field sobriety test. And certainly the police wouldn't have been allowed to do that if in custody Mr. Roberson invoked his right to counsel in silence.
Do you agree that if the Commonwealth had just turned the volume down and introduced the video, that would have been okay?
I don't agree with that because, again, it's kind of like at that point you're conducting a field sobriety test.
And field sobriety tests under the law are non-incriminatory and don't require Miranda. They're balancing tests.
I believe that applies. That's true when they're conducted outside of custodial interrogation.
What if they had just put him back in the cell and trained the video on his cell and he's heard to make all sorts of rambling statements and behave in a way that might indicate that someone was impaired? Does that video of the cell come out? Does that have to be excluded?
I don't think there was a video of him in the cell.
No, I'm saying assuming that there was, assuming that instead of having the video of the booking area, they just keep the video after he's certainly requested counsel and indicated he doesn't want to talk, but then they keep the video on him because they're concerned about him because that's just protocol. Does that video also get excluded?
I think that would come in if it wasn't a police-prompted interrogation. If there was just a video of him in the cell and he was ranting and raving and it wasn't at the behest of police questioning, then I'd agree that that would probably come in, but that's not the case that we have here. What we have here is a case where, and we hear it all the time in field sobriety tests, that it's not just the physical performance on the test, it's the defendant's ability to follow the instructions, to respond to them. And that's exactly the way that the judge used the evidence here. I direct your attention to page...
Is the way the defendant responds to instructions testimonial?
I think it is when we know that it's context specific, right? So when the police are investigating an OUI and the question is intoxication, then investigation into really anything is likely to produce incriminating evidence, and that's exactly what happened here, I would suggest. And I think that the judge used it exactly for that purpose, and I refer you to page 8 of the transcript where the judge discusses the fact that he's going to use the evidence to determine whether he's able to comply with instructions, things of that nature, exactly how you'd consider a field sobriety test.
So was your position then that once an arrestee invokes their Sixth Amendment right to counsel, or for that matter, the Fifth Amendment right to be silent, that it's a dead stop and the police then are to avert their eyes?
No, I'm not suggesting that.
Okay.
I'm suggesting that at that point, the police can't initiate further questioning without honoring the right that's been invoked and use the evidence that's produced by it to prove an element of the charge that they're investigating.
What about in the context as here, I think, and I do think it's a fair interpretation, that they're trying to help them get out the door. And they're just saying, well, we can't bring the bail commissioner in, your wife's waiting out front, and look, buddy, if you don't cooperate, you're stuck here all night. Don't you think they'd have some obligation and wouldn't have a different complaint if they just stuck him in the cell and left him there until the next morning without even attempting to get a bail commissioner down or to get him on his way and move him home?
Yeah, I think that if we delve too deeply into the subjective mindset of the police when they're conducting this questioning, then we're probably asking for trouble. Maybe they were well-intentioned. I'm not arguing otherwise, but I'd say that they should have known, based on their words and actions and continuing the investigation after the invocation, that they were likely going to produce incriminating evidence, and that's exactly.
I want to sort of follow up to Justice Brennan's question and put aside the questions that are asked. Invokes his right to counsel. At that point, they don't give him his right to a phone call? They don't give him his right to a breath test? Is that what you're saying, that it just stops?
Well, I think I'm glad you brought that up. Well, he would have a right to call his attorney, I would say.
How does that get done? If they can't ask him a question, if they can't talk to him, how does that happen? How does he know about his right to his phone call? How does he know about the breath test rights? See, we're trying to, I think Justice Brennan and I are trying to find out what's the slope here? What can be done? What can't be done after the invocation of counsel?
Yeah, I think that, procedures reasonably calculated to actually produce counsel at that point would certainly be admissible. And if there's statements volunteered without police prompted questioning during that procedure, then that's likely admissible. But I don't think that's certainly not the case that we have here.
All right, how about the right to a breath test? So he invokes counsel, he still has the statutory rights to a breath test. All of that, as you know, in this case, or in most police stations, is on a video camera. Are they supposed to shut the video camera and give him the breath test questions? How does that work?
I suggest that if a defendant invokes his right to counsel prior to them getting to the breath test and blood test portions of, if you want to call it the booking process or investigation, I mean, certainly that evidence relates to an investigation in this matter. So I think if you invoke the right to counsel prior to them getting to that point, the police would be required to actually produce counsel to advise him whether or not he should take a breath or blood test, because these are certainly statutory questions. Yes, I know there's statutes about it, but they're legal questions that really affect the defendant's ability not to incriminate himself. And
It's not what the law is, though, right? The police have no obligation to get a person counsel prior to the election of a breath test. So this would change that.
I think they have an obligation to allow him to contact his own attorney. They don't have to appoint one for him. I agree with that.
You see where I'm going with this?
I think I do.
Okay, let me follow it a little bit. He invokes his right to counsel. They say, you have a right to call a lawyer. He says, I don't have a lawyer. Now we get to the breath test portion. What happens? Do they ask him, you have a right to a breath test? Do you want to take it? Do they not ask it because he's invoked counsel? Do they just ignore that statutory right? What do they do?
I believe that they could do it at their own peril. I don't think that they should be able to admit the results at trial afterwards if they've not honored his right to silence and to invoke counsel, and he's basically said he doesn't want to speak to them, and then they initiate further questioning to the effect of, hey, actually, we know you don't want to talk, we know you asked for your attorney, but look, here, take these tests anyways. I think that there might be, in some cases, caretaking reasons to do that, but I don't think, given the important rights that are at stake here, it should be admissible.
What if they asked him to do field sobriety tests at that point? Just nonverbal field sobriety tests?
If
At the station, in the booking area?
You're saying
After he said, I want my lawyer, I want my lawyer, I want my lawyer, I want my lawyer, I want my lawyer.
if he says all that and then he initiates the discussions and says, actually, I want to take a field sobriety test.
What if they just say, okay, but in the meantime, we'd like you to take a field sobriety test? You know, you see that line right there? And they give them the heel to toe. Or they say, give them the one-legged stand test.
Yeah, I don't think that's admissible, and
Do you have any authority for that? Any authority at all that would support that?
Yeah,
position?
I direct the court's attention to Commonwealth versus Air, which is 31, Mass Appeals Court 17. And in that case, there was a roadside field sobriety test conducted, but I'd suggest that the reasoning of it implies that the right to counsel must be honored if a defendant's in custody before subjecting him to a field sobriety test.
So I don't know that case. Is that, so you're saying in that context, if they're on the scene, if they're at roadside and the defendant says, I would like to invoke my right to counsel a little more clearly than your client may have, at that point, they're not permitted to give field sobriety tests?
I think there was an issue raised in that case whether or not the field sobriety test could come in prior to Miranda, and because the defendant wasn't in custodial interrogation, the court said it comes in and it's not subject to Miranda because of the fact it was conducted at the roadside when the defendant wasn't in custody, that it was still an investigation at that point. They were trying to determine whether or not they needed to place him into custody for operating under the influence.
Counsel, I'm not aware of a case that requires Miranda prior to field sobriety tests, whether he's in custody or not in custody, because again, they're not incriminatory, self-incriminatory. So if you have a case that says once he's in custody, prior to field sobriety tests, he has to be given Miranda, I'd welcome that case to read it.
I'd say that the reasoning flows from the Supreme Judicial Court's decision in Commonwealth versus Woods, where they're discussing Commonwealth versus Moniz, which was the United States Supreme Court case. And the citation for Woods is 419 Mass 366. And specifically, I wanted to direct the court's attention to page 373 of that decision, where they talk about, similar to this, booking questions which are asked after someone's been placed into custody and during an OUI investigation. And they said that some of the questions weren't permissible because the police should have known or knew that it was reasonably likely that their questionings would produce evidence that demonstrated the defendant's intoxication. Basically, the content of his answers would demonstrate the fact that he was intoxicated. And that was incriminating evidence which couldn't take place, even though it was one of their general booking questions that they typically asked.
Counsel, I want to shift to something else. You make in your brief, you state that when the judge reached his verdict, he was giving findings of fact when he made those statements. Do you have any case law whatsoever that suggests when a judge in a jury waive trial sort of makes comments upon his verdict that those should be considered findings of fact by an appellate court?
So interestingly, not directly, and I did research this quite a bit. I found the analogous civil statute that talks about clear error when a judge issues findings of fact. And another case, Tremblay, which talks about applying that rule of civil procedure to a criminal case. The fact of the matter is, I think that it's this court's job to affirm the verdict. And if this court has demonstrated evidence on the record that the verdict wasn't actually rendered to satisfy the due process clause, which is what I suggest would happen here, then this court's really in no position to affirm the verdict. Now, I think the judge could have just said guilty and called it a day, but I mean, the fact of the matter is that's what he didn't do. And the fact of the matter is also that they're saying we can't mention those findings, but he brings it up to say that there was no prejudice by Mr. Roberson admitting to alcohol use because the judge didn't discuss it in his findings. So certainly they can't have it both ways. I would say that if you're inclined to just ignore the fact that the judge made these findings, then you have to really consider the fact that there was prejudice caused by Mr. Roberson admitting to alcohol use.
What about the statements by the judge that he would not consider any out-of-court statements, but he was looking at how the defendant balanced, how he was, whether he was responsive, things like that? Are those findings that we should consider?
No, I don't think so, Your Honor, because I think, like I said, that whole video should have been thrown out. And even if we get to the point where, let's say that you disagree with my first argument and the video's in, so much of the video was just infested with inadmissible evidence, and we really have no idea what the judge actually looked at. And what he says happened in certain instances didn't really happen. So he says also that in rendering his findings, he says it's based on basically the video portions of it, right? That he looks drunk and then he turns around and falls into the wall, and that's the video aspect of it, right? But then he also, throughout the course of the trial, talks about how he's going to rely on the audio aspect of it when he talks about the fact that he's gauging the clarity of his responses in the back and forth exchange between Mr. Roberson and the police. So the fact that he's relying on both aspects of it throughout the trial, I would suggest that you can't just separate one from the other due to that fact and due to the fact that they both stem from the rights violation that takes place at the 13-minute mark. And I think that answers your question, but maybe I went off the rails a little bit there.
The last question I have, my colleagues might have more, but in your last argument, or one of your arguments, you talk about that the judge didn't necessarily find him guilty of operating a motor vehicle while under the influence of alcohol at the time, and he relied on what happened at the police station to find that. It sounds like you're trying to make an extrapolation theory without mentioning those words.
Now, I think that under the due process clause to prove an OUI, it's a crime that happens in a moment in time, right? You have to be intoxicated while you're operating. So the judge, although he certainly credits Officer Julian Suarez's observations at the scene, he goes on to say that really the overwhelming evidence is what takes place at the police station. And he never actually says, oh, by the way. And I would suggest that in stating the way he did, that he's suggesting, you know, this video is what's convincing me beyond a reasonable doubt that he's intoxicated. But he never actually says, I'm convinced that he was intoxicated beyond a reasonable doubt while he was operating the vehicle. And so I think there's really, whether he would or not, maybe he should have, maybe he could have, would have, but at this point, this court is speculating upon findings that suggest that there wasn't actually a crime here, and that's a violation of the due process clause.
All right, thank you. And we'll hear from Mr. Hanson.
Good morning, Your Honors. If it pleases the Court, Arne Hans for the Commonwealth, representing the Plymouth County DA's office. I'd like to address Justice D'Angelo's last point. I don't believe that the defendant's claim is actually supported by the record. I'm going to quote exactly what Judge Horhan said in that case when he found the defendant guilty. Quoting from the transcript, page 46 and 47, Judge Horhan stated, "And I believe that his ability to operate was impaired by alcohol from what I saw in the video and the officer's observations." It's clear that he doesn't delineate between the officer's observations on scene as well as what he observed at the station. I just don't believe that's factually supported.
You don't disagree, though, that judges commenting during delivery of a verdict is fraught with peril and not ideal?
I think the Judge Horhan was creating a record here which stated his reasons for finding the defendant guilty, which is certainly helpful for this court.
Which we don't have jurors do.
Correct.
Okay. And then speaking of creating a record, not to jump right on it, but let me ask you this, and not to, again, not to attack the judge who's doing a difficult job down there, but when the judge says, I don't want to watch the 2 hours of the video, and then the DA says, I have some points to jump to, but we don't know, we know there's a 5-minute, roughly 5 minutes from 12:46 in the afternoon until 12:52, so what's that, 6 minutes that the judge watched, and then from 12:52 p.m. until 12:55 p.m., another 3 minutes. How do we know what 6 and what 3 minutes the judge watched of the 2-hour video, and how does that impact our ability to determine whether he decided this case fairly on all the facts?
So that is the unfortunate part about this case. We don't know. Outside of the one portion where the judge references that the defendant is being placed in the cell. So we know that they watched that portion, which was the initiation of the booking process where the defendant was uncooperative, refused to answer the questions. The officers were patient with the defendant. They gave him multiple chances to cooperate. They said, no, that's not going to happen. And then they're like, okay, we're going to put you in the cell to let you calm down, think about it, and maybe after a couple of minutes in the cell, you'll cooperate with us. And that's exactly what happened.
Don't we have to kind of presume that the judge, he could have watched any part of this? And we have to look at the whole video and see if there's anything in there that somehow entitles the defendant to a new trial.
That's fair. Unfortunately, we don't know exactly which points he watched.
Hypothetically, let me ask, what would you suggest we do with this? If it was a jury verdict and the clerk inquired of the foreperson and the foreperson said, you know, how do you find, and the foreperson said, well, just to let you know, we only read 3 pages of the 200-page medical record, but we still find him guilty. What will we do with that?
That doesn't matter, because jury verdicts are unimpeachable outside of showing that there was an external influence, so it's a very different animal.
So it's analogous, you'd say, to that? Or no, would you say it's different?
So with respect to...
They're both fact finders.
It's an issue that really hasn't been explored in criminal law. It was explored in Tremblay, which was a civil case, and then they applied the civil standards to that case. But I would point out that that court examined 2 different types of evidence. They examined testimonial evidence, which was the live witness testimony, and then they examined the documentary evidence. In this case, is the booking video. So where there's testimonial evidence, we can't look back on the judge's decision because we weren't in the room with him, and he makes findings of credibility and weight based on the testimony and how it comes in. It's something that doesn't really translate into a transcript where an appellate court could go back and say this is actually not the case. Whereas the documentary evidence, the video, can be reviewed de novo. But Judge Horhan gave us clear findings stating that he relied both on the officer's testimony as well as the video. Certainly this court would be in a different position if it was just the video that the judge relied on, but where he relied on both, I don't believe it's appropriate for this court to go back and be a fact finder, which is what Tremblay cites.
I guess for better or for worse, I guess what I'm asking, and maybe it's not raised, whether there are any due process concerns where a fact finder in a criminal case affirmatively states that they're not reviewing the exhibits and making a decision on only part of the trial record.
I'm not aware of any such cases.
Should there be? That's, I guess I'm asking. I don't think that there clearly aren't, but what's your take is, again, just a matter of basic fairness and justice when we have a trial record that clearly demonstrates that the fact finder didn't review all the facts that were presented and that were, I mean, again, if both parties agreed, well, this is the important part, this and this, and we agree that that's the only part you have to watch, and then they identify in the record, that's easy for us. But here we have something that's been marked as an exhibit in full, without limitation, and the judge on his own says, I'm not going to watch that exhibit. I'll watch a part of it if you want to show it to me. And we don't know what he watched. As a basic issue of fairness and due process, do you think we have a problem here?
I wouldn't say so here because the defendant had an opportunity to object to that, and the defendant could have stood up there and said, hey, I want to play this entire 2-hour video because I believe that it shows. So where there's no objection to the court's assessment that I would say I only need to watch 9 minutes of this, the defendant was certainly in agreement with that. The defendant certainly also had an opportunity to present any other evidence from the video that they would have believed to be exculpatory, and they chose not to do so because, which would suggest that wasn't the case.
Let's talk about that for a second, the presentation of the video. There's clearly things in that video that are inadmissible, even just going over the rights of the breath test, which we've already talked about a little bit. You make an argument in your brief that the judge is presumed to ignore inadmissible evidence. Well, if there's no objection to it and it just comes in, it's all admissible and it can all come in for its full weight, can't it?
Correct.
The judge doesn't really limit himself if there's no objection, does he?
That's fair. So at the beginning of the trial, Attorney Souza, who handled the the case objected to two portions of the video coming in, that being the hearsay relative to the 911 call as well as the breath test. The judge recognized that and didn't take that into consideration, and the judge stated, look, these are the things that I'm looking for. I quote what he says in my brief. I don't want to paraphrase here and get anything wrong, but he's very clear with, this is why I'm looking at it. I'm looking for his demeanor and the way that he responds. He's looking for indicia of intoxication.
So I'm looking at page 8 of the transcript where the Ms. Souza says, I'll stipulate to the video with the stipulation that I object to, and then the judge says, right, I'm not going to consider anything, some out-of-court statements. My focus on the video is how his condition is at the time of the booking, his clarity or lack of. So is that the judge kind of instructing himself, as judges are presumed to do, properly on the use of particular evidence?
Yes, I would agree with that. I think he's recognizing that he's not going to take the out-of-court statements, and he's looking for the video for specific things that are admissible that he can consider.
Let's move to the right to counsel part of the case. The defendant here invoked his right to counsel 6 times prior to being taken back to the cell. Approximately 14 minutes later, he's brought back, we think it's 14 minutes, assuming the clock is correct on the video. He's brought back in and given certain rights and asked questions. Why isn't that a valid invocation of his right to counsel, and all questioning should stop?
So I would first address the fact that this is during the booking process, and it's very established that the booking questions are not custodial interrogation.
If they're not designed to elicit incriminating evidence, but where the charge is OUI, isn't a question about have you had anything to drink incriminating? Even if it's part of a regular booking process, or making sure there is no suicide risk or whatever it might be.
Certainly that's inescapable. So that question is part of a series of questions designed to evaluate someone's mental health and condition at the time, so that in the event that there's a medical emergency or the
Basically, do you agree that that statement should not be considered?
It doesn't appear that the judge considered it in this case.
Well, I'm asking you, if there had been a motion to suppress, should the motion have been allowed at least as to that statement, where the defendant says yes and gives the thumbs up when asked if he's been drinking?
I would disagree with that, and I think it's important to note that they ask the question and then they immediately move on to the next one. If this was part of the police interrogation, the officers could have asked
Wholly
follow-up
apart from
questions.
whether it's part of an interrogation, if we agreed that it's part of a routine series of booking questions, as it appears to be in the video, still, in the context of an OUI, it is eliciting incriminating information, isn't it? When the defendant says, yes, I've been drinking, doesn't matter what the subjective purpose of the police is in asking that.
It's certainly inculpatory, but the other part of that analysis is whether or not it weighed on the overall verdict, and it does not appear that Judge Horhan
Okay,
considered
but just
that.
to be straight on the analysis, do you agree that it should not have, it would not be admissible if there'd been a motion to strike? I mean, sorry, a motion to suppress.
Yes, that's fair.
So how do we know? Are you agreeing with defense counsel that the statements the judge made at his verdict stage are findings of fact that we have to adopt?
Yes, I would agree with that.
And is there any case law to support that? These were ruminations of the judge. Here's why I'm finding the defendant guilty. I'm finding him guilty because I credit the police officer and the stuff on the video. So everything in that statement are findings of fact, but if he doesn't say it, we totally exclude it and think he didn't consider it, because that's what we do on other cases where a judge does make findings of fact, as you know, like motions to suppress. Anything that's not in a finding, we don't find that the judge found credible. So here, we're limited only to what those words are that the judge said as findings of fact as to why the defendant's guilty in this case?
That is the record we have. I mean, that's...
I guess the question, I don't mean to jump, is that just editorializing and commentary, or is that actual factual finding? It's a tough one. I think that Garassi, if you're familiar with that case, deals with a judge who made findings in his verdict, but it was more of a legal finding, and it got reversed because it applied the law incorrectly. I don't think we have a case that says that if a judge as a fact finder, comments on a verdict, that is then restrictive of the evidence that can be used to determine whether it was sufficient evidence. But if you agree that that should be the law, that's an interesting thought.
Yeah, I don't have anything further to add to the analysis. I don't have any case law to support that point either.
I guess what we're asking is, should we make that case law? Do you think that's a fair rule of law in the context here, or in many cases where judges seem compelled to comment on their guilty verdicts?
I don't have an answer for the court.
Okay.
Does the court have any additional questions from the Commonwealth? Thank you.
So, all right, thank you. And the next case we'll hear is number 23P 358, Commonwealth versus KEVER Castillo-Martinez. And I did want to let those waiting here know that we will be taking a short break after the third case. Sorry if I didn't get the defendants. I hope I did okay on the last name, but, oh, sorry. The first name I probably didn't pronounce correctly, but I'll let defense counsel correct me on that.
Good morning, may it please the court. Catherine Jansen on behalf of the Commonwealth. The Commonwealth respectfully requests that the court reverse the allowance of the motion to suppress. I think here, when viewed in the context of the detective's following of his training and experience, he had reasonable suspicion that there was a pre-planned meeting to exchange drugs, and there are, I would say, at least 6 factors that would support this. The arrival of Combs' car in an area that is known as a high drug area, the fact that Combs was known to police to sell THC products, and the fact that Combs, when he arrived, appeared to be looking at something, his head was on a swivel, and that he appeared to be manipulating something, which in the officer's training experience was consistent with waiting for somebody to show up, often in his experience, a drug transaction. The arrival of the defendant's car a few minutes later, that he walked right over to the car empty-handed. He got in, the two leaned forward to each other and appeared to be manipulating their arms. And then when he exited the vehicle, he had a plastic bag in his car.
Attorney Jansen, can we break this down a bit?
Yes.
All right.
Sorry.
So breaking it down, let's start with the reputation to sell THC,
Correct.
or known, sorry, to sell THC. And you cite the Kennedy case, which is still good law, but it's, what, 30 years old? Mm-hmm. And don't seem to be a lot of cases directly on point since then. You agree with that?
Correct.
So what is your position with respect to how and to what extent we can consider that sort of reputation? A police officer knows him to be a drug dealer or knows him to be specifically a THC seller, or what are the factors that we're looking at? Size of the community or not the size?
Conceitedly in Kennedy, I believe there's a little bit more, and of course in Kennedy we're dealing with probable cause, not reasonable suspicion. In Kennedy, that officer hadn't arrested that other party. I believe there was testimony that that officer had, other officers had arrested for drug transactions, and that person, there have been complaints in the community about that person. In Kennedy, it goes so far as to say you don't need convictions or indictments for a known reputation of a drug user. I think here, where we have from I would say it's presumably a reliable source from the police reaching out to Gloucester PD that this person's known to sell THC. I think it could obviously have been more developed. How do they know that?
That's my question. What from the record would allow us to impute any sort of reliability to Sergeant Connor's statement that, yeah, we know that guy, he's a THC dealer up here in Gloucester?
I mean, I think the record could definitely be a little bit more robust on that point because there isn't anything about arrests or the basis of knowledge that that person had stopped him. I think there's a fair inference, and maybe the court won't agree with this, that a police officer saying that this person's known to us in the Gloucester Police Department to sell THC suggests that they've had interactions with him where he's been selling THC, either complaints or arrests.
Well, that's the part. Couldn't it just be we've heard complaints that he sells?
And in
THC?
Kennedy, there were complaints that that other party had been selling drugs. So I do think that's a factor to consider. And while it might not be dispositive or the most weighty factor, again, we're looking at a reasonable suspicion, which is lower than probable cause, and we're looking at the totality of the circumstances. So I do think it helps. I don't think it, or at least it doesn't negate reasonable suspicion, I guess I would say. And I think it takes it, I do think it does take it out of the cases of Kearse and Barreto to some extent where there was.
Let's take it out of this equation. Keep going, because I'm curious as if you take that out of the equation, you have two people meeting in a parking lot and one person gives something to another. And that would be enough in your opinion?
I think it's enough in this opinion because when you look at the cases and whether there are factual circumstances that color the nature of the transaction, I think here it's not just a generalization of a high crime area, it's specific to that location, the Liberty Tree parking lot mall, that it's a high drug area based on this detective's substantial experience having made arrests and done drug investigations in that area, which is the purpose of why he's there. I think it's the fact that you have the nature of his experience of people coming in, that when somebody's doing something non-illicit, they tend to either go into the mall and conduct their business, or when they meet up with somebody, they get out of the car, that this is following the precise script of how a drug transaction occurs in that parking lot, which he testified to on transcript 34 through 35. And I think while obviously you don't need to have an exchange, I do think it is important and what was absent in Barreto.
I called Justice Brennan up the other day and said, I'll meet you in the mall. I want to give you your wallet that you left in my house. And exactly what just happened here happened. Can the police stop Justice Brennan's car or my car because they think something illegal just happened, just because it was in that mall?
I think when you're looking at the nature of the fact that he appeared to be looking around, his head's on the swivel, that means something to this police officer. And so I think while there may be innocent explanations for what occurs, that's not dispositive of the issue. You have to look at it through the lens of the officer's training and experience, which was substantial here, especially in this area, and that this followed the precise script. Oftentimes in cases where it's not enough, there's no testimony from the police officers.
After the Mercedes parked, Williamson witnessed the driver looking at his lap, looking around and moving his arms. So he looks around. It's not that his head's on a swivel. It's not that he's looking back and forth. He looks around. So you park your car and you look to your left, you look to your right. That's looking around.
I think this court can use the swivel as testified to the officer because that was uncontroverted testimony.
That wasn't a finding of fact. Finding of fact was looked around.
Correct, and you can supplement the finding of facts with uncontroverted testimony, and that was uncontroverted that his head was on a swivel. So,
I'm not suggesting you ought to or need to concede it, but I just want to understand your position. Stripping away the Liberty Tree Mall parking lot where the detective testified he's witnessed hundreds of drug transactions. Take that out of the equation. Take out of the equation the call to the Gloucester sergeant detective where he says, yep, we know this guy sells THC. And what you have is simply the observations, okay? Again, without conceding that we have to base it on that. If we based it solely on that, is it your position that that amounted to a reasonable suspicion? And if so, why?
I don't think that would amount to a reasonable suspicion because I think that this is why you look at everything in the totality of the circumstances, which I think the court understands. And that's why it's important, because there's stuff to color the transactions and the nature. Oftentimes, even though it's now become a little bit more disfavored by the appellate courts in terms of the nature of the area where the transaction occurs, I do think there's specific and articulable facts to ground in the specific location for the nature of the activity. And so I'm not going to concede that point. But and oftentimes in the other cases where it's not enough to color the nature of the transaction, the court always points out, and it's not in an area known to officers for high crime or high drug, whatever they're investigating. So I think you can't isolate these factors, one of these alone, or when you strip one or two away, it definitely weakens reasonable suspicion, or even does away with it. But that's why you look at everything in the totality of the circumstances. It's the silent movie of Kennedy, which, again, that was probable cause. I think here we're at a lower standard of reasonable suspicion. And I think when you look at it through the lens of the police officer and his training experience and what occurred, and especially his testimony wasn't sparse about why he felt like that was enough in his training experience, that he has this experience, but what people do when it's illicit or non-illicit in that specific area. So, and the appellate courts have been clear that if there's reasonable, innocent explanations, that doesn't mean, through the lens of a police officer, it might have a more nefarious or sinister outcome. So
One statement that the judge made, I want to ask you about. It says, Williamson has occasionally stopped people who exchanged items in vehicles only to determine that the transactions were non-illicit. So he's had reasonable suspicion, apparently, in other cases, he's stopped innocent people. Is that okay?
I think that's what happens and why a threshold inquiry is allowed, because you're confirming or dispelling your suspicion. So I think just because he's had that experience before doesn't necessarily negate the other experiences that he's had, where more often than not, which is what his testimony was, is that this is how drug transactions occur, especially because his training experience, people are trying to secret away what they're doing in their car as opposed to being more out in the open.
Can I go back to this statement of the Gloucester officer for just 1 second?
Sure.
Is the consideration of that a binary matter where either it's the officer on the scene can take it into account or not, or is there any question of how much weight it could be given? So if the officer in Gloucester says, yeah, he's got a reputation for selling THC, I don't really know, we've never caught him at it, or he's never been arrested for it, never been convicted. Does that mean it's not entitled to any weight?
That's an interesting question that I frankly hadn't thought about. I think probably, I don't know if you're getting at an angular Spinelli maybe kind of argument, that maybe it's not entitled to weight. I think it has, I think oftentimes when you're looking at a tip, and my understanding of the case law will probably be that without, the substantial reliability and basis of knowledge, that then you don't really afford it weight. And so I think it probably is binary, would be my understanding of the case law. But again, that's just going off of my head. I candidly had not.
Well, if you find something that says otherwise.
Yes, I will be sure to let the court know.
Is your position that the horizontal or collective knowledge doctrine applies here, that somehow the Gloucester police officer has become part of the investigative team, or not so much?
Well, they're not necessarily part of the team, but I do think, maybe horizontal collective knowledge isn't totally, maybe it's not a totally appropriate application in this case, because here it's based on what the officer's knowledge was. He had this knowledge at the time. I think horizontal collective knowledge deals with officers who are investigating at the time and what's known to them and maybe whether or not they have communicated it at that time. So
Let me ask, I guess on the facts of this case, let me ask you this hypothetical, is if this was not a detective with experience of however many years up in Gloucester, it was just a guy that Williamson knew up in Gloucester, called a friend, called a guy and said, hey, you know anything about this? I know this guy, he's sitting here, I think he's selling drugs, know anything about him? And he says, oh yeah, well, yeah, everybody knows in Gloucester, that guy's a big THC dealer. Any difference there?
whether it's a police officer or not,
Yes.
I think there would be a difference, and I would just point that I feel like the police officers would have a more substantial basis of knowledge for that based on the nature of their work and inferentially that they've encountered this person, received complaints from this person from the community, and possibly made arrests. Obviously, the record is devoid on that, but If the court has no further questions, I'm happy to rest on my brief.
All right, thank you.
Thank you.
We'll hear from Mr. Berry for the defendant.
May it please the court. Good morning, Justices. I'm Mark Barry for KEVER, Castillo-Martinez. I'd like to start where Judge Brennan kind of ended off with the horizontal knowledge doctrine. As I read the report and everything that's happened in the lower court, there was no indication that the police officer from Gloucester was involved in an investigation at all. And I think the case, the most recent case regarding horizontal knowledge, brings that up several times throughout the finding of that case. So I don't believe that applies here. I do state to the court that we evolve and everything else evolves with us. If we looked at somebody walking down the street 25 years ago with their head down going like this, we might think, what is wrong with that person? And quite honestly, nowadays we see people walking down the street going like this, and there's more of them that are doing it than aren't doing it. We have technology, we have moving at rapid paces, outpacing my ability to understand what goes on with my cell phone half the time. What we didn't have 20 years ago is we didn't have eBay. We didn't have Facebook Marketplace. We didn't have Craigslist. We didn't have a lot of people likely in parking lots of malls or shopping centers.
Can I ask, Ms. Barry, let me ask about that. And I think the detective may have addressed it somewhat. In those transactions, he indicated his experience is that it happens outside of cars. And in some sense, it seems to me it makes sense that if you're meeting a stranger in a parking lot on an eBay transaction, you're not hopping in their car. Because you never met the person, you don't know the person, you're doing it in an out, plain view, if you will, place where, right? Isn't that sort of common sense?
Well, it is and it isn't. I mean, we hop in Ubers and Lyfts where we don't know if the person is really an Uber driver or not. And as we've all heard in recent news stories, there's been some problems with that. So I would say that it's reasonable not to jump in somebody's car if you don't know them, but I think times have changed. I think Uber and Lyft have been a big part of that change. And it's interesting that Detective Williamson said that one of the reasons that that drug deals happen in the parking lot at Liberty Tree Mall is because it's got good access. It's centrally located off of 128. It's near the North Shore of everything. And that would ring true for meeting somebody to buy something from Facebook Marketplace.
Can I follow on that a little bit? Sure. And we assume that the more recent cases disfavor this whole notion of a high crime area. Mm-hmm. Is there a distinction here, though, where the detective said, not this is just a high crime area, but I have seen hundreds of drug transactions in that particular parking lot. And as you just indicated, that lot is a place where drug transactions happen because Gloucester, Lynn, great spot to meet, ship it down, keep it going. I mean, I'm paraphrasing a little bit. Isn't that a little bit more specific? And if so, why is that at least not a factor that should be considered?
Well, I will suggest that the Liberty Tree Mall parking lot and the buildings that are the stores in there are over 40 acres. There's parking for, I believe, 5,000 cars in and around that area. It's probably the biggest lot in the North Shore. I would also suggest that the North Shore Shopping Center has a lot of parking and a lot of access to different highways also. Yes, just Detective Williamson said he had seen hundreds of drug deals in that parking lot. He did also break it down to different portions of the parking lot. And Detective Williamson that was his main job for, I think, for quite some time now. At least the last 8 years, that's what he does. He was with the DEA, I mean, very well-trained officer.
It's like you're arguing for the Commonwealth now.
I know, he is well-trained.
And he said that particular part of the parking lot.
That particular part of the parking lot is something that he parsed out during his testimony that he was looking at. But he had made hundreds of arrests. But he also said he had made mistakes and arrested people that...
But the lie is that you don't have to eliminate every possible innocent explanation in order to establish reasonable suspicion, let alone probable cause.
No.
The fact that he'd made mistakes before, or in a sense, that doesn't mean he didn't have a reasonable suspicion. And in that sense, it wasn't a mistake. It just turns out that his, whatever suspicion he had did not turn out to be accurate.
Correct. I agree with that.
Well, let me ask you about that. If somebody has reasonable suspicion in 50 occasions, and out of those 50 occasions, 30 of them turn out to be innocent explanations, does that change a reasonable suspicion to a hunch? And it's a bad hunch.
I agree it changes it to a hunch.
Where is the line here? He talks, according to the findings, he said he's seen numerous exchanges in that parking lot for non-illegal reasons. And he talks about how most of the time they get out of those cars. But then he says, I've occasionally stopped those people, and I was wrong. So what do we do with that?
Well, I think you have to look at that. I think that's a hunch. That's a hunch, and sometimes the hunches are wrong, and a hunch is not enough. He's fully stated that he's made mistakes. If you had 30 out of 50, yeah, I'd say that's a problem.
Now, that wasn't explored in the hearing as to why he stopped those people based on what factors, what led him to stop those, correct?
That is correct. I would like to say that with regards to the information from the Gloucester Police, with the technology we have, I would presume that if somebody said he's known to sell THC products, your question next would be, well, has he been arrested? Has he been charged? If not that, I'm sure Detective Williamson has the ability to run Mr. Coombs's record.
He was asked that. My memory is he was asked that and he didn't remember.
Yeah.
Is that right? Yeah.
That is correct.
Okay.
So I would take that out of the equation. All of what Detective Williamson saw was from 50 to 100 yards away through binoculars. And I agree with you, Judge D'Angelo, that you stop in a parking lot to meet somebody, you are going to look around. Doing something, manipulating something with your fingers in the front seat of your car, I mean, he could have been changing radio stations, checking his wallet, it could be a number of things.
Attorney Barry, do you agree that although the judge may not have made the finding specifically that it was not controverted, that the detective had seen what he described as hundreds or made hundreds of stops in that lot, and about 5 of them were eBay or Craigslist? Do I have the numbers about right?
That's what the testimony was, yes.
Okay, and is there any reason why we can't, if it's uncontroverted, supplement the record with that as a fact that we consider?
I think you can.
Okay.
You don't think that it undercuts the judge's ultimate conclusion in a way that makes it something we can't consider under Isaiah I and Jones-Pinnell? I'm not suggesting that you should think that. I'm just wondering what your position is.
That's a good question. I'm not sure I have an answer to that question, Judge. It was the testimony. I think you can add it, but I don't know that that helps or hurts.
Anything else? No, almost.
Any further questions?
All right.
And I'll rest.
Thank you very much. Our next case will be 23P37, Commonwealth versus Joseph Martinez.
Good morning. If it may please the court, Elizabeth Mello Marvel for the Commonwealth. As you are aware, the Commonwealth is here today to ask respectfully that this court reverse the motion judge's decision allowing the dismissal of the attempted indecent assault and battery charges as well as the attempted rape of a child. As you are aware from the motion judge's decision, he relied primarily on Commonwealth v. Rose and Commonwealth v. Bustle. That was on page 5 of the decision, where he found that the gap between the defendant's actions and the completion of the crime was just too large. And the reason that he thought that it didn't rise to an overt act, the defendant's actions, was because the child, it was uncertain whether the child would comply with the instructions. It's the Commonwealth's position that that's not the appropriate measure, whether or not the child complied, a child who cannot consent to such activity to begin with. In looking at an attempt crime, you're looking at the defendant's actions and what other actions have to be taken. In looking at Rose and Bustle, there were additional actions either for the defendant to take, as in Bustle, he was going to a location, presumably had made arrangements to have intercourse with a child. And the court said, well, that's not enough because when he got there, he hadn't engaged with the child yet. He still needed to persuade the child. He could have changed his mind. Here, there was nothing else for the defendant to do. He was directing her to touch herself, to insert her fingers into herself. He was persuading the child.
Can I ask you a question about that? As I read, or as I listened to the recordings and actually read, which I think in the brief, it appears that there was actually, under your theory, a completed rape. That there was a completed rape, that the child actually did what she was instructed to do in this situation. Am I missing something? It's specifically where she says, after she says, just squeezing legs real tight, all right, I will, here we go.
Correct. That is in the transcript. However, you will notice that the indictment was for an attempted...
No, I'm asking why.
Rape. Because of further communication with the child, she then denied. So the Commonwealth did not have a basis to go forward on that and instead remained with the attempt. So I apologize for any confusion.
No, that's okay. That answers my question, though.
But that was why. So again, in looking at some of the other points that were brought up in regards to there weren't any threats, it wasn't forcible, it's the Commonwealth's position that that is not necessary. And it's pretty clear in looking at, for example, the Davidson case, 68 Mass App Court 72, it's a 2007 case where the defendant was telling the child not to tell, that they had a game of hide and seek where if she was the one that was found, she then would have to touch the defendant's penis. There was no indication there that there was force. And again, given that it's a child who cannot consent, the law deems it to be forcible and against the will of the child anyway.
Do you have any case where there was a conviction for indecent assault and battery or rape when, I don't know how to put this, but the penetration or touching is done on the child itself, not on the defendant and not on the defendant touching the child, but the child touching him or herself?
Yes, if you look at the case of Portanova, that was actually an adult, but it was a mentally retarded adult. In that particular case, the defendant was directing the victim to rub her own vagina, and the court found that that was sufficient. Essentially, it's where the victim basically just becomes the mechanism by which the defendant accomplishes the goal. So in other cases, and there are variations of that, there's that example. There's also the Newby case where the defendant forced the children to perform sexual acts on their mother, and that was under threat. There's also the Guy case where the defendant forced the victim to perform oral sex on another female. So there are variations, and again, touching of the self is more of the Portanova case.
Those, as I recall, all involve the defendant's physical presence. And it seems to me that that was really at the essence of the judge's decision. Can
Correct.
you address how and why we should, because it seems to me it would be new law. I suppose Carter gets there a little bit, but how psychological manipulation from a distance may or may not be every bit as much as convincing or inducing as physical presence?
I would argue that, in fact, it's not new law. If you look at a case such as United States v. Polk, P-O-L-K, that is 508 F Sup 2D 89, that's a 2007 case, a little bit different in that it's looking at child pornography, but individuals have been prosecuted and convicted in this particular matter. He was having conversations with who he thought was a 13-year-old child, and encouraging that child, directing that child to take explicit sexual photographs of themselves and send them to him. Turns out that he was talking to an undercover officer. That's irrelevant because that goes into factual impossibility, and that's not a defense. But here, I mean, the court found in this particular case, which had to do with sentencing, they said the fact that he wasn't in the same room, that he was not physically present with his intended victim, was of no matter. So in following that line, the whole purpose for these laws is to protect the children, to make it where they are not sexually exploited. And in keeping with that line, it doesn't matter whether they are in the same room or not, because you're accomplishing the same. If you are successful as a defendant in carrying out your actions, whether you're in the same room with the child, in a different room, on the phone, over the computer, you're accomplishing the same harm. So it'd be the Commonwealth's position. It's not really new law in looking at similar statutes. And the other piece that
I asked
of course.
just about the Davidson case, which talks about inducing, and in that case it was inducing a child under 14 to engage in indecent touching. What is required to establish inducing? I gather you're saying it's not required that there be force or a threat of force when you're dealing with a child under 14. But what's enough? Is the mere suggestion, why don't you touch yourself, is that inducing?
I think it is. I think you have an adult. This is a child. They're not on equal footing. There is a conversation about persuading the child it's building a relationship.
Well, does there have to be an inducement, like I'll give you candy if, or I'll give you money or a Game Boy?
I don't know that there necessarily has to be that. I think you look at the totality of the circumstances. In a situation where you have a threat, you don't necessarily have inducement.
What about the relationship of the parties? Is that required? Does there have to be a relationship? What if there's a stranger that calls somebody's house and, pardon the expression, talks dirty to the kid that's on the other line? Is that enough?
I believe it is. Actually, Your Honors, if I did mention it in the brief, another reason that the Commonwealth is seeking clarification from the court is that within a 5-month period, there have been conflicting decisions on this very issue. In the matter of Commonwealth versus Theodore Williams, that was a Superior Court case in Plymouth County where the defendant made contact online with two whom he believed to be 13-year-old girls, strangers to him, and made a lot of the same comments that the defendant in this matter made, as far as instructing the children to masturbate, to touch themselves, etc. There was a motion to dismiss filed in that matter, and in that matter, the Superior Court judge there found that under Davidson, it was sufficient for the attempted rape, attempted indecent assault and battery. So, which was a conflicting decision to this matter, where it's essentially the same. Again, not a conversation had about the relationship between the parties, whether they're strangers or not, whether they're family members or not, step-parent or not, doesn't seem to be the issue. The issue is that it's an adult instructing the child in this sexual manner.
Can I ask maybe a less abstract question? On page 13 of your brief, you list the elements of indecent assault and battery on a person over 14. And it seems to me that consent is missing. It wasn't addressed, it wasn't part of the decision here, but isn't consent an element if the child is over 14? In fact, isn't that the distinction between indecent A and B, under and over, is consent?
Again, I apologize, Your Honors. I would ask to be able to submit a 16L letter. I am not clear at this moment why I would have left that out.
Okay. So
So
assuming for the moment that consent is an element of indecent assault and battery on a person or a child, but a person over 14, do you have anything that would support the position that this child did not consent to the behavior, other than, I suppose,
I
I mean,
guess,
consent being, sure, a relative term depending on the,
In other words, this is a probable cause that the child did not consent, which
Well,
is an element.
I guess you would have to look at the totality of the circumstances then. I guess it could be argued that the child that was playing hide and seek with the adult consented to touching his penis because she thought it was a game.
We're talking about a
But-
person over 14, or 14 and over.
Correct, but-
Where consent is a defense, so the Commonwealth as an element has to prove lack of consent.
Correct.
Is there probable cause here that once this child, the victim here, had turned 14, that the child did not consent? And I would say particularly where the defendant is alleged to have said, and maybe the recording bears this out, the defendant said to the child, once the child was 14, touch yourself if you want to.
I think again, it's a totality of the circumstances. If you look at simply two sentences, I think you lose all of the, you lose what could possibly go to whether it was truly consensual or not.
So what else in that call would support the idea that this was not consensual?
I think
Probable cause purposes.
if you look at the conversations that they had, many of which were not sexual in nature at all, but had more to do with a child who was excited to be building a relationship with a father that she did not truly know and had not seen since she was a toddler, the conversations that they had about how great it would be when he got out of prison, how they would go to the movies, he'll buy her clothes, how accepted and loved she felt. There's an element of manipulation there, coupled with the idea that he's telling her, you can never tell your friends about us. If you ever
In the
tell...
context of this case, once the victim turned 14, how could it then be an attempt when we have consent as an issue? Because originally I was along Justice Brennan I thought it had been done, but you've now clarified that the victim says she didn't do what was suggested. So if we follow that through to once she's turned 14, if she hasn't completed the act and consent is an issue, how can there still be an attempt?
Correct. Well, and going to that is where I indicated I would like to submit a 16L letter in regards to the attempted indecent A and B over 14. I think for the attempted rape, the age of consent is 16, so we don't run into that issue. Again, I would need to submit additional information on that, but as far as the under 14 and the rape, that's not a concern.
You can submit that and the defense can respond.
Thank you.
how important is the Carter case to your theory? And specifically the part of it that talked about the relationship between the parties, the ability to manipulate, the verbal communication carrying more weight than mere words. Is that only go to the overt act, or is it, to your mind, it goes to the actual, the element that requires that came reasonably close to occurring?
I think that goes more to the issue we were just talking about consent and the totality of the circumstances. In looking at an overt act, you're looking at the acts of the defendant.
Right.
And what he did to further, what his actions were in furthering and accomplishing the goal of whatever that particular completed act was.
I guess
Whether or
let me
not
clarify
the
my
victim-
question. I don't mean to, but let me clarify my question. Are you relying on that case for the proposition that someone can, from miles and miles away, whether behind bars or not behind bars, control someone else's behavior through their words.
In which case, I'm sorry, the Pope case?
That's Carter, the manslaughter.
I
The
think.
boyfriend, the
Correct.
girlfriend who
When you're
convinced her
talking
boyfriend
about
to
mere
commit suicide.
words, perhaps meaning being more than mere words, I think it goes to the strength of the words and perhaps an individual's ability to resist. Meaning, I think it goes to Justice D'Angelo's point about if it's a stranger that calls and says, hey, do this, a victim may be more likely to be like, no, and hang up, as opposed to a coach or a family member or a friend where they might be like, okay, because of that relationship and the trust issue. But again, that goes to the vulnerability of children and why these statutes exist in the first place.
All right, we'll have to leave it there.
Thank you.
And we'll hear from Mr. Wood.
Good morning, Your Honors. Joshua Wood from Joseph Martinez, along with Attorney Maura Berry. The Commonwealth presented testimony in front of the grand jury that essentially Mr. Martinez had a series of sexually explicit conversations while he was a sentenced inmate at MCI Norfolk in 2009 over several months, and most importantly for this argument, during 2 separate telephone conversations, made a suggestion to his biological daughter that she touch her own genitals, and in one instance, that she insert her fingers inside.
We've got the facts.
Let me just cut to, for me at least, cut to it, what in my mind is a critical issue. Does inducement require physical presence?
Inducement doesn't require physical presence, but this is not an inducement case. So all of the cases cited by the Commonwealth, including Carter, including the cases involved, like Davidson, involve consummated crimes. And in all of those cases, the court makes very clear that consummated crimes are different than attempt crimes, because attempt crimes are a very special exception in which ordinarily non-crimes can be considered crimes when the planning phase of that crime gets very close to the completion of the crime.
So let me ask, but the judge allowed the motion in the findings, said in large part, or if not simply because, the defendant had no control over whether the child in fact followed his lewd instructions. He was not in her presence and therefore could not make her follow her suggestion. Well, so is it your position that presence is necessary to have control over a person's behavior or to make someone else follow one's suggestions?
I think it's an important part in most cases, but it's not an absolutely necessary condition. And what's important in this case is that you have an attempt charge, a charge in which there was no consummated crime, and you have a person who's incarcerated cannot even determine the level of compliance with his own suggestions.
Why does the knowledge make a difference? I don't quite understand, I confess, the point you're making about attempt. The defendant did everything he could in this situation. He could not have come closer on this theory of the crime of the attempt to making it happen. He said, why don't you touch yourself? Here's how to do it. I mean, that's not like he's on his way to her house, but he never gets there.
No, this is actually, the situation is much more roundabout than I think respectfully is suggested. These are 2 people that do not have a previous relationship with one another. They had minor contact as father and child before this child had any living memory. And since that time has essentially been out of her life and serving.
How does that make a difference to whether this was an overt act that came very close to commission of the offense?
Because his words didn't carry the weight in and of themselves to influence her behavior from a distance under these circumstances, unlike a lot of the other circumstances where they had a long period of relationships. And
is it possible to separate whether what he said to her was constituted sufficient inducement or coercion or whatever might be required to make out the crime versus whether there was an overt act? Is it possible to separate those 2?
I think that, I think that I think that the two questions are related to one another, and they can't be fully teased out from one another, because if there was sufficient inducement for her to commit these acts, then perhaps it would have gotten closer. But what you see in these conversations is oftentimes the statements of the sexual conversations are begun by the daughter, and often as soon as she presents any resistance to engaging in these acts, he doesn't continue to perseverate and say, well, you should do it anyway. In one case, he says, you might as well touch yourself, and when she says, okay, I'm doing it, then later says, are you doing it? In that same conversation, she says, no, because I'm at a KFC, and he says, yeah, probably not the correct place to do it, and completely backs off.
Taking that point, assume for the moment that, which is not out of the realm, that she has got her phone and she's recording herself, and that there is evidence that she actually does, so that they have the same exact conversations, and the only additional factor is there is evidence, video evidence, that she actually does penetrate herself with her finger as he's telling her to do so. Is it your position that that would not be a rape?
It is my position, based on the idea that I made the argument that I'm asking the court to affirm on additional grounds. I don't think that's a rape, because if you look at the other case law dealing with the very narrow circumstance in which a person can be guilty of sexual assault without any physical contact with the victim, those cases always involve some type of compulsion, either an incentive or a type of punishment in case of, or in the case of Portanova.
Okay, but Davidson didn't involve compulsion, did it?
Davidson was not an attempt charge. I'm
asking if it was the completed crime.
If it was a completed crime, in all of those cases, there is the involvement of some type of coercion. Like in the example.
What if the inducement is affection or love for someone who's vulnerable, lonely, abandoned, desperate for parental attention, suicidal, by your client's words, bipolar and psychotic? In that situation, then withholding or giving love or affection or attention, isn't that an inducement every bit as much as here's a Game Boy or here's a piece of candy?
Well, what we have here, well, that's not actually what happened here, because, for example, my client's affection and conversations, as the Commonwealth just conceded, were not dependent on her engaging in these kinds of activity. Oftentimes, he would engage with her on completely innocent topics, and she would bring the conversation, say, can we talk like boyfriend and girlfriend, and would start engaging with him.
But this is a probable cause question.
I understand. So what I'm saying is, so getting back to my previous argument, all of the cases that involve situations in this very narrow group of cases in which contact between the perpetrator and the victim is not necessary for sexual assault involve some type of coercion. Now let's talk about the case of Portanova, which was just cited by the Commonwealth as an example where mere words existed. That wasn't a case involving mere words. In that case, the defendant brought a mentally retarded woman to a hotel room, isolated her, engaged in several acts of violence, and then after those acts of violence and violent penetrative rape, then uses mere words to say, demanding that she touches herself. And the court found in that case that it was tantamount to an order, and fear was the mechanism of coercion. None of that is existing here. Right. None of that is existing here. What we have in this case is we have a young girl who seems to be constantly turning conversations back to this kind of fantasy talk. And sometimes even there is evidence of the defendant not wanting to engage in it, and her. Can I
just stop you there? You're not suggesting that your client didn't engage in some sort of psychological manipulation when he tells her to tell her grandmother, who's her effectively her parent, to F off, so that then she'll boot you out of the house and we can be together, things of that sort. That he's not grooming her from the beginning and then manipulating her on some level. That it's not all her.
I'm saying that those statements are so remote that they are very far away from being an overt act in the legally relevant sense. If you look at those kinds of statements, that in that case, the statements about living together in the future requires my client to, if we look at the gap between what is being said and the fulfilled desire, we're talking about finishing a lengthy prison sentence. This is a child who is in a guardianship, who he has no legal right to contact. There would need to be major efforts in order to get to a position where he could be in a place where he could have unsupervised contact with this girl. There is a number of steps, far more steps than existed, for example, in the Hamill case, where there was a number of steps taken and there still was insufficient, much more than the Buswell case. All of the case law suggests that this closeness between the overt acts and the completed crime needs to be very close. It needs to be sufficiently probable.
I'm still trying to understand why we can't separate the overt act issue from the required level of coercion issue.
I think we can.
All right, so if we go back to the example where she has a phone and she's recording herself, and we can see that she starts to slide her hand down towards her crotch, and then she, in response to his saying, "Why don't you touch yourself?" and then she stops at the last minute. Why isn't his saying, "Why don't you touch yourself," an overt act?
Because there are a number of external circumstances that can still come into play, and without any additional information about his attempt to overcome those external circumstances, there are a number of steps between...
What's the remaining step? Her finger gets within an inch of her genitals, or a half an inch.
Her agency. And I know the Commonwealth wants to...
Okay, so why isn't the agency a question of whether he has induced her, or whether he has coerced her or threatened or otherwise, as a separate matter from whether he's made engaged in an overt act?
There is the question of overt act. On the question of whether or not, had she touched herself, whether that would have been a completed indecent assault and battery or rape, I think the question is one of inducement or a question of compulsion. And the question is, does that exist here?
So you're saying that inducement is not enough in an attempt crime?
What I'm saying is, this is not inducement. This is a person saying, I'm not saying these conversations are not deeply, deeply troubling, and it's also completely, I think, off the point to suggest that the purpose of these statutes is to protect children. Mr. Martinez is still facing criminal prosecution for other charges. This is a question of whether this falls under the attempt statute. And that question is going to be answered based on what he actually did. And what he actually did was engage in conversations. When he tells her to touch herself, that's not an instruction. There's nothing about the nature and logic and grammar of that sentence which is of an order or an imperative. It is a suggestion which she, in every case, disregards.
All right, well, if he's in the same room with her and he says, "Why don't you touch me, I'll give you $1,000.
Yes.
Is that inducement?
It is because of the incentive, the compulsion that's there, which doesn't exist in this case. The incentive that would overcome the resistance.
All right, so why don't you touch me and then we'll go get an ice cream cone afterward. Is that inducement?
It could be under certain circumstances if the incentive was sufficient.
How about, why don't you touch me? Yep, I'm sorry. Why don't you touch me and I'll be your father and I'll love you?
Well, two things about
that. Is that any different from an ice cream cone? Some people might think that's better than an ice cream cone.
Well,
we're not being slightly
there's two
facetious.
problems with that. Number one, it's never the case. There's no evidence that him being a father was ever the premise on which these conversations occurred. He interacts with this young girl, his daughter, on a number of levels that don't involve any sexual talk, and he never says, well, if you don't touch yourself, then I'm just getting off the phone and not doing it. In fact, I've spent a lot of time with these tapes, and I've listened to them. You will hear again and again and again, they talk about a number of life issues.
That's a question of fact for the grand jury to
decide.
decide. So go back to Justice Brennan's question. Is the promise, or even in the victim's mind, if I do this, he's going to be a good father to me? Is that enough inducement?
I'm not sure that it is. I don't think it applies in this case because that's not the case, but I don't think that it is in and of itself, particularly when his ability to actually have a relationship with her is so far off, and we're talking about an attempt statute, where the connection between those two things has to be very, very close. So it's not true here. Mr. Martinez never makes, in the context of the statements that are presented by the Commonwealth for your consideration, there's never a conditional statement. If you do this, then I won't do this, or I will do this. There's not fear. There's none of those traditional inducements that you see throughout the case law that involves this very narrow group of cases involving when someone's touching of themselves could be considered essentially the instrument of Mr. Martinez.
So if he'd said to her over the phone, touch yourself and I'll give you $1,000 when I get out of prison, would that be inducement?
I think based on and she doesn't do it, is this an attempt charge or is this a completed act?
The attempt
It's
charge.
an attempt. I
Yeah.
think based on Hamill, I think based on the Buswell case, I think it's still too remote because a number of events have to occur in order for that final inducement essentially to happen.
So that's your same answer if he says, if you don't touch yourself now, then I'm going to kill you when I get out? Is that inducement? Is that coercion?
That could be coercion because Portanova discusses how fear can be used as an inducement in the present, and even maybe future violence might be enough under those
But he's
circumstances.
still just as far away from it. I mean, what if he's serving a first-degree murder sentence?
I think that the difference between fear versus the $1,000 is that fear of a future event can affect you right now in a way that joy over a, potential down the road payment, which is extremely sort of abstract and potentially won't happen.
So the grand jury could find probable cause in the case of the threat to use violence, but not probable cause where there's an inducement in terms of a reward.
And I don't even want to say that they necessarily couldn't, but I think it's a lot closer question. Here, we're nowhere near anything like that.
All right, we'll have to leave it there.
All right, thank you, Your Honor.
All right, we'll take a 15-minute recess, and we'll be back out to hear the remainder of the cases.
All right.
All right, we'll hear the next two cases, and then we will be having a panel change before the final case today. But this next case is number 22P841, Richard Zeal versus the Commonwealth, and Mr. Burkholder.
Good morning, Your Honors. Fred Burkholder on behalf of Mr. Zeal. I was just having a conversation with my brother here, and you know, this case in Mr. Zeal's circumstances are not foreign to this court. He's been through the situation twice. So there's very little that I can say about his history that's going to change what occurred. Obviously, there was a decision made previously with regards to his 2003 conduct, being sexual and the like. So really, all I want to focus upon, and in rereading the brief, I think it covers much of what I want to say. But all I really want to highlight is that, you know, there's admissions that ASPD remits. And then it becomes a problem for a qualified examiner to take a look and say, what's the benchmark? You know, has he met those you know, improvements and the like that are necessary to say that he no longer has sexual urges? And I think what we have in this case is, maybe if it's not enough, it's certainly the beginnings of that. All right? I mean, if
Counsel, what improper opinions or information did the Commonwealth's expert provide to the jury?
Well, I think that I lay them out in my brief, but I'll certainly repeat them to you. With regards to Dr. Bell, the following admissions were made on cross-examination. His last sex offense was in 1990. He has no sexually inappropriate behavior while held. He has 6 OBRs over the last 3 years, not a number that he considered large, and he had no reaction to a 2021 assault showing some degree of sexual regulation, or I should say self-regulation. Dr. Callistra said the 2003 conduct did not suggest sexual deviance. Burnout occurs without consideration of treatment. Has exhibited increased control conduct by his lack of OBRs or diminishing number of OBRs. He has no signs of deceitfulness. Diminished impulsivity is also in decline based upon his reaction to the 2021 attack he was involved in. No longer categorically denies his offenses, and he's learned some patience, anger, control, and avoidance. So, I mean, we both know what was said to the contrary, so I don't need to repeat that, and that's my brother's responsibility. But the point is that he's getting there. And I guess the other thing I want to talk about very briefly is this, and it's HIL. I have a problem with HIL. I've had a problem with HIL since I started doing this work. I just reread it again this morning, and you know what it does is it puts these guys in a situation where they are forced to make a decision whether or not to engage in full treatment. I reread it. That was the problem with HIL. He didn't participate. He didn't cooperate, so therefore they had no way to glean whether or not he still had any continued urges, so therefore they were allowed to extrapolate. All right? My guy hasn't been engaged in full treatment either, but he's starting to. He's in thinking for change.
May I ask you why? It's okay. Why are your arguments, and maybe you seem to be acknowledging they are, why aren't they just about credibility and weight?
Because I think you still have to make a determination whether or not sufficient evidence existed to demonstrate he lacked sexual urges. And I think that the lack of OBRs, I've always been one that believes in conduct rather than words means more. And when he's been able to go 3 years, and more importantly, he has never had any OBRs that involve any degree of sexual involvement. George, the individual, did, and the same thing occurred with regards to Keel, but not my guy. For Christ's sake, my guy's never even had sexual intercourse. And his conduct that he's been convicted of involved out of overclothing contact, and there was no, weapons that are involved.
But if the jury credits the government's experts, there's enough, isn't there?
Well, my argument is directed verdict. It shouldn't get that far. It shouldn't get to the jury.
All right, so let me change it slightly. In a light most favorable to the government, the expert's testimony is enough, isn't it?
That's where we disagree. I don't think it is, because if you read George again, which is the major decision that says ASPD, it can be a personality disorder which can form the basis for a sexually dangerous commitment, it says and I wrote it down because I didn't want to get it wrong. There has to be a persistent pattern and it combined with other evidence. And what we don't have here is the other evidence.
Why isn't all the OBRs other evidence?
Because number one, in George, there were 53 of them.
Well,
my guy
isn't
didn't
the
have
number
that
of OBRs that constitutes other evidence really a matter for the jury?
Second one, and more importantly, they didn't involve any sexual components. And that's the big difference. That is without any question, the elephant in the room is my guy has, although he's from the beginning of his adolescence, when he was given his glasses and his learning disability was noted, and he started having difficulty dealing with people, and specifically members of the opposite sex, he's always up against it, and as a result of that, if you were to meet him, he's a diminished man of diminished stature with glasses that are this thick, and it's hard to not have that reaction to him, and I represent him. So you can see how a female who he approaches and has no experience in approaches would have that. But I have to go back to two things. One is the nature of his conduct. Certainly it wasn't appropriate. I'm not saying that it was. But in the general scheme of things, I do a lot of SORB work as well, and you look at, in a case called 496-501, they look at the nature of offense on a continuum. And if you looked at Mr. Zeal on that continuum, he's not going to fall at the far end in the extreme end. He's going to fall somewhere in the middle. And when you can go through the number of years in custody that he has without having some demonstration of continued sexual urges via an OBR, that's the only thing that he can do is prove himself by not doing that. Otherwise, he's going to get into treatment. Frankly, between you and me and the lamppost, he's already in it. But the point is that at least he's starting at this point. And I think that a judge has a responsibility to take a look and say, you know, based upon everything that I've just said, maybe this is a case where, you know, he's spent his time and enough time has passed. I mean, it's been 17 years since he had any conduct, and that wasn't even sexual other than the court saying that it was.
Can I just get clear on the static 99?
Yes.
Is that, and I know I could go to 10800 or probably the testimony here to look it up, but as the name implies, is that limited to static factors or does it take into account?
It's static factors alone. Okay. And it was amended to static 99R. I don't know how many.
Yeah, I'm sorry, that's what I meant to ask about. But the R is, it's still all static factors.
That's correct. There's a stable 2007 which covers the dynamic factors, which we never see in these, and frankly, is used in SORB hearings and is beneficial because they do a combination of them. I really don't have anything further to say other than I'm welcome to any questions.
All right.
Thank you.
Thank you, Mr. Burkholder. Mr. Mansfield.
Good morning. May it please the court. Brian Mansfield for the Commonwealth. In this case, the trial judge properly denied Mr. Zeal's motion for directed verdict at the conclusion of the Commonwealth's case, and then again at the conclusion of all the evidence. The Commonwealth offered sufficient evidence on all of the elements that the Commonwealth must prove beyond a reasonable doubt to have Mr. Zeal found to remain a sexually dangerous person. In fact, the element of prior adjudication as a sexually dangerous person was stipulated at trial. It's stipulated on appeal. Mr. Zeal has agreed in his brief on the second element, which revolves around the mental condition, either a statutory mental abnormality or a personality disorder, that antisocial personality disorder has been found as a sufficient mental condition to support a finding of sexual dangerousness, and that on that diagnosis, he also concedes that there was enough evidence of that for the jury. And the issue raised in Mr. Zeal's brief is purely on the likelihood. The Commonwealth offered evidence of Mr. Zeal's long history of antisocial personality disorder, which drove his sexual behavior in the community. They offered evidence that that antisocial personality disorder still manifests itself currently, even at the treatment center, both with his obtaining observation and behavior reports, but also in other ways, particularly how his interpersonal reactions with people, how he deals with treatment, that it has caused him problems with treatment, that he still had problems at the time of trial, denying his sex offenses, not seeing himself as a sex offense.
Any thoughts at all on the issue of I suppose you call it a catch-22 of getting into and complying with sexual offender treatment programs and whatever that may involve, as opposed to then saying, oh, I don't want to go there and not doing it, which either way may be held against you if you're the person in that position?
Well, certainly sex offender treatment has been shown to help reduce the risk of sexual offense recidivism. And as the evidence was in this case, Mr. Zeal presents with a number of dynamic risk factors, those risk factors that are amenable to treatment, that were present at the time of his offending and were present at the time of the trial, and he had not dealt with them. Now, certainly, antisocial personality disorder generally tends to remit as somebody gets older. That was not the case, certainly at the time of trial for Mr. Zeal. So, I mean, he does have the choice of not attending sex offender treatment.
Those were current diagnoses, correct?
Correct.
From the QEs?
Yes, so it was both that they were present at the time of his offending in the community and that they were present currently, to the extent that they would continue to drive sexual offending and make him likely to reoffend sexually if he were to be released into the community at this time. I'm not sure if I fully answered Justice Brennan's question, but
I think as well as it probably can be answered, but thank you.
If there are no other questions, the Commonwealth will rest on its brief.
Thank you.
Thank you.
Okay, our next case will be number 22P607, Young versus Town of Lee.
Good morning. Good afternoon.
Just let's make sure we're all situated here. Ms. Knight.
Yes.
Can we just reset the clock to? Thank you. All right. Okay, thank you.
Okay, thank you. May I please the court? I'm here on behalf of the appellants in this matter, some of whom are in the courtroom here today, to ask this court to reinstate the appellant's complaint, which is filed below, or in the alternative to declare that the town of Lee did not have the right to sign the settlement agreement that they did in 2020.
May I ask, is there a live dispute here in the sense that are there remaining obligations either on the town or on GE under this particular agreement? I'm not suggesting that the cleanup has been completed or that I know nothing about the status of the landfill. We don't. It's not in the record. But yes. Is there a continuing issue that would be affected by whether this agreement is valid or not? Since the First Circuit, I think, has disposed of the case and...
Your Honor, it would not. Nothing has happened in terms of the start of the cleanup in the town of Lee or beginning the building of the PCB dump. What's happened is there have been arguments in the federal court on this, different arguments as to the location where it's going to be. But as to the agreement that I'm asking you to, or the signing of the agreement that I'm asking you to hold as null and void, which is what I asked for in the complaint, was signed by the select board of the town of Lee in 2020. I say that because it's a different set of people now.
Yes, but what is the continuing, what would be the effect if a court were to rule today that the town's signature on that agreement is void? What would the practical significance of that be?
I would suggest that it be up to the town of Lee then to undo the contract, whatever.
Okay, but what would undoing the contract mean? What obligation is there under the contract that remains to be performed? It seemed like the principal obligation was for the town not to appeal if a revised permit was issued that was substantially the same as what the agreement said.
Right, that's right, that they wouldn't appeal, and this would be the
Well, that's done, right? The town's opportunity to appeal the permit is over and done.
Well, this would change that, I think, because we'd go back to the beginning of the agreement where it was not validly signed in the first place. So,
Okay, let's assume that the town had never agreed not to appeal the permit, but as a matter of fact, the town did not appeal the permit, and now the time for doing so, I would assume, has passed. So what effect would voiding this agreement, if a court were to do so, have on the issues that agreement addresses? What obligations are there that remain to be performed?
there's nothing else other than the appeal has happened. The town of Lee was not part of that appeal as part of this. But there's no, what it would do, and I think it's up to the town of Lee to then figure out how to handle that. But what I'm asking this court to do is to look at what happened here and to make a ruling.
Did the town agree to do anything or not to do anything other than not to appeal the issuance of the revised permit?
Your Honor, what's contained in the settlement agreement, it does not, I'm not even sure it says that they won't appeal. It's very vague as to what the basis of the settlement agreement is based on. It just says what the terms are going forward.
So what is the town not free to do with the agreement in place that it would be free to do if the agreement were not in place?
The town would be free to then fight go back to the drawing board and fight GE and the EPA as to whether this location whether there should be a PCB dump in the town of Lee.
What does the agreement bind the town to do as far as the location?
It binds the town to allow a PCB dump to be placed within 2 miles of the center of town, within 15.
What provision of the agreement requires that?
It's in the settlement agreement, which is attached to the complaint that I filed below, and it discusses, and I'm trying to find the location there. Well, I guess you'd have to take judicial note. I mean, there's, in terms of location of where it is, that is within 2 miles of the center of town.
Okay, but what in the agreement binds the town to accept or to issue whatever permits are necessary or to not oppose that location? I'm asking, we don't need to go outside the record, I don't think. The settlement agreement is in the record.
Yes.
I'm wondering what provisions of the agreement are still present some live issue.
So, I was thinking it would start on the record of page 20, which would be 22, and goes through to page 25, and what that indicates is what the town of Lee has to allow GE to access to this land to build this dump there. And that sets forth what the terms are, that the PCB dump will be 20 acres in size, how tall it will be, what the liner has to be underneath. So all of those things, nothing has happened yet. There's been no breaking of ground. Nothing has happened. And this is a very long, slow process. And it seems that the selectman's position has been, we're on this road in the wrong directions, but let's just stay on it anyway, even though it's going the wrong direction. Whereas they never had the authority to sign that settlement agreement in the first place. It breaks every single. It's a violation of the open meeting law, which.
All right. Your main argument on appeal, it seems to me, is under 43-2.
Right. So I didn't.
So why don't you get to that?
Thank you. So the statute, as you know, says, as I pointed out in my brief, I mean, this bylaw and every other bylaw that I cited in my brief, as well as the town's meetings, sort of the handbook, all speak to how the town meeting is the legislative authority. Only they have the authority to make decisions that are important to the town. And at the time,
clearly 43-2 authorizes the select board to do something. So we could have a lot of discussion over what's important. I have no doubt that this is an important matter to the town, but that's not really the word.
And that's not the argument.
The word, yeah.
Thank you, Your Honor. The argument is that the select board, which is largely an administrative body, the town law that was enacted, 43-2, states the main purpose of that clause is the second sentence, which is no settlement of a claim or suit obligating the town in an amount in excess of $1,000 shall be made, except as authorized by law, without the consent of town meeting.
Can you, and I think you're probably going there, can you explain then how, so your theory is that by giving GE the right to build, that has value that then exceeds the $1,000? Is that?
Yes, Your Honor.
And is there any case or any precedent for that you're aware of?
Well,
Other than makes sense, but.
Yes, it's common sense. I also painstakingly broke down the words. So obligating isn't just a payment of cash, which is what the town of Lee's position is. Oh, we didn't have to pay them $1,000, so there's no loss or cost to us. But GE in the settlement agreement is going to pay the town of Lee $25 million. So that's not a gift. That's quid pro quo. The town of Lee is losing $25 million in value, in business, in infrastructure, in all
But how is that an obligation?
The obligation is allowing GE to use the town of Lee to do this.
The language of the bylaw says, which does not require payment by the town. Which does not require payment. It doesn't say anything about giving land. It doesn't say anything about value. It says does not require payment. So in this case, the town is not paying GE anything.
No,
so why is it violating the bylaw?
Because Your Honor, you're looking at the what would be the exception clause to that bylaw, and that says payment. Okay, so there's the selectmen at their discretion can compromise and settle a claim which the town is party to, which does not require payment. Payment is referring to in this section $1,000.
In other words, that's as if the town is getting sued and they have to pay someone in excess of $1,000. That's okay?
Right. We're
in agreement on that.
That's the exception clause. The main clause is...
Why is that the exception clause? I see two sentences there which have to be construed together in a manner that's consistent.
Yeah, well, I see it as the exception clause because the gist of the bylaw, the two-sentence bylaw, is that the town meeting has authority over all settlement claims that are $1,000 or more, essentially, or obligate the town in some way that will cost $1,000 or more.
Does 43-2 govern suits that were brought by the town?
I think it really only applies to when the town is liable, but in this case, the town is actually in a plaintiff sort of way.
All right, so if the town brings a claim, if the town brings a claim against a contractor or someone who hits a stop sign with their car and damages it, if the town wants to settle that claim, if the select board wants to settle that claim, does the select board have to go before town meeting?
If it's less than $1,000 or $1,000 or less, they have the discretion to settle it.
Wait, so I'm saying if the select board, if the citizen who hit the stop sign says, okay, I'll pay you $750, can the select board accept that without town meeting approval?
Yes.
And if the citizen says, I'll pay you $1,500?
That's true, but they're not getting anything, Your Honor, but that's not...
No, I just want to make sure I understand your answer. If the citizen says, I'll pay you $1,500, does the select board have to get town meeting authority to accept that $1,500?
I would say no to that, because that's an administrative resolution. It's not costing the town
What gives
anything.
the select board the authority to settle a claim by accepting $1,500?
I mean, I would think that as agents of the town in their authority as the select board, but that's not the scenario that we have here. It's simply not. This is a scenario where the value that the town is giving up is $25 million. Otherwise, they wouldn't be getting a payment. Obviously, that's based on something. So, and there's no question, there's never been a dispute that PCBs are toxic and carcinogenic, and there was a huge push to not have any in Berkshire County, and the select board knew that, but it wasn't the select board that was negotiating in the settlement agreement. It was the rest of River, and the rest of River was a group of 5 towns, Lee, Lennox, Stockbridge, Great Barrington, and Sheffield. They had one lawyer in there working for the mediation, and Settlement agreement was negotiated, but it was the town of Lee that signed it, and they had an obligation before signing it to take the terms of the agreement to the town meeting and say, this is what we've got here. Is it hands up or down as to whether or not the town of Lee will accept it. They didn't do that. That's what we're asking. They should have done that. And I think they didn't do it because they knew the town meeting would never agree.
I'm having trouble understanding the difference between Justice Sachs' hypothetical and here. Let me tweak it ever so slightly.
Okay, good.
A truck is driving on a road and the truck explodes and causes $5,000 worth of street damage, okay? The town sues the trucking company. Says this was faulty, the truck shouldn't have exploded, it shouldn't have caused damage. They settle that claim for $5,000. They can do that under this bylaw, as you suggest, correct?
They can accept the $5,000.
It can accept the settlement and get $5,000 for that road damage.
Well, Your Honor, I actually appreciate and understand your confusion because I would have these same issues. I think generally speaking that this bylaw really only refers to when the town is a defendant and
It doesn't
liable.
say that.
I know
It
doesn't
says
say
that the
but-
town is a party. So in my hypothetical,
Okay.
the town sues the trucking company. They are the plaintiffs.
Right.
They say you caused $10,000 worth of street damage, but we don't want to go through the lawsuit. We don't want to hire lawyers. We'll settle it for $5,000. Okay?
Okay.
They can do that under this, can't they? That's what I thought you just said to
I think-
Justice Sachs.
I believe that they can, that this, I don't know that this statute allows them to do it. I think that they have the administrative powers to
Does
settle.
43-1 allow them to do it as agents to institute, prosecute, and defend any and all claims, actions, and proceedings?
Yes. I think, yes, that's correct.
So
But
if we flip the hypothetical to this actual case, GE is settling a claim with the town of Lee, and what the town of Lee is giving up is some land. The value of the land, it's really irrelevant, but they are getting $25 million for that land to settle the lawsuit or the potential lawsuit. I'm failing to see how that is any different than the road explosion that I just gave you as a hypothetical.
well, because in this instance, they have this statute only allows them, gives them discretion to settle claims of $1,000 or less. And I would submit that based on the legislative history that I included in my addendum, that really means they're authorized to settle nuisance claims. And I understand in your hypothetical, you're saying the town is the plaintiff, but in this instance, if you accept that theory, then they abuse their discretion because they only have discretion and they do not, this is an unprecedented situation. And the bylaws were never intended to allow the select board to settle this kind of case behind closed doors without the consent of town meeting. Thank you.
All right, thank you. Mr. Pollard.
Good afternoon. May it please the court. Attorney Jeremiah Pollard for the town of Lee. A procedural facet of this case that I think is worth mentioning is that the town of Lee, as part of a 5-town group, did challenge citing a dump in the town of Lee, in fact, in Berkshire County. And unfortunately,
This is before.
This is before.
Okay.
And that was in 2016. It was appealed by G, went to the Environmental Appeals Board, and we lost, unfortunately, which requires an assessment of where you stand in the litigation and what to do. The bylaws that have been referenced in the record appendix that designate the Board of Selectmen as the agents acting as the body that will handle litigation do in fact authorize that board to act as plaintiff.
I did want to ask about the bylaws. For a long time, the law in the Commonwealth was that a court could not take judicial notice of the content of the bylaw, and that has not the SJC has suggested there's some flexibility there, but they haven't really changed the rule yet. Is there any disagreement here between the parties about what the text of the bylaw actually is? I didn't see any in the
There is not, Your
in
Honor.
the papers, but I just want to make sure.
There is not, Your Honor.
Okay.
Traditionally, town meetings will enact an article year by year authorizing the Board of Selectmen or putting to the legislative body, which is the town meeting, a proposal that the Board of Selectmen will act as agents for the town in litigation. Lee made that, obviated the need to do that every year by adopting a bylaw that authorizes the Board of Selectmen to do that. The next bylaw, that's 43.1, 43.2, says that if there is going to be payment of $1,000 or more, you have to come to the legislative body, which is basically an attempt to facilitate settling, claims that are nuisance claims, $1,000. Nothing in those deals with when the town is settling a case of this magnitude, where the town is getting a payment, and the town's sole obligation in the agreement is to not appeal, as it had before.
So since the time for appeal of the revised permit went by and the town did not appeal, is there any continuing significance to this agreement? Does it continue to impose any obligations on either the town or GE?
It's an excellent question, Your Honor, and it really could, because the agreement is vague enough that I believe the language is that the town of Lee would not challenge the permit, the EPA permit. And we're dancing on a fine line right now with another case that we're looking at against Monsanto, which created PCBs. And the town's position is to bring that case, was not going to challenge the permit. It might require an amendment of the permit if we get what we're looking for, but the town is still obliged not to challenge the permit. What the town can do to challenge the permit is almost nothing, because it was treated as a CERCLA permit, Superfund permit, which sets aside the town's bylaws, sets aside the state's regulations in terms of environmental cleanup, and how the EPA makes an ultimate decision in this case is going to be the penultimate factor.
Can I ask, is there anything in the settlement agreement, and I didn't see it, but it might be there, that obligates the town, or that essentially releases claims that the town might have against GE, or that individual residents or property owners might have against GE for future damages arising out of the construction or operation of this landfill? Are those claims, could those still be brought, or does this agreement release them?
There is nothing in that agreement that waives claims by individual residents of the town of Lee or the town as a plaintiff claiming a general nuisance, should the cleanup create that. None of those claims have been waived. This town's sole obligation was to not appeal in this case.
So if a neighboring property owner said there are PCBs in my well or in my the soil around my house, GE, you've got to clean it up.
If there's contamination, GE, you've got to clean it up. If my property values have gone down, GE, you've got to clean it up or fix or remedy it. If there's a nuisance presented by the dump, whatever claims that are formulating with the breaking of ground and the actual installation of the dump potentially are out there. And we could go on for a long time with what those could be, Your Honor. But the fact of the matter is that the town itself has the ability to go into an executive session to weigh those options. While this matter was underway in 2020, February of 2020, there was most certainly, if not ongoing litigation, because it had been remanded by the EAB, there was a prospect of litigation. And so the town was well within its rights to place the item on an executive session agenda And the town of Lee did that with the specificity that's required and is often absent, and I'm afraid to say, with a lot of towns. They just say, we're going into executive session to discuss litigation strategy. That's not what they did. They said specifically with regard to the EPA cleanup and to discuss the rest of the river. So
Prior to the executive session, were any town members allowed to participate in any discussion about whether there should be a settlement of this type?
well, there was the mediation itself was something that the public was able to comment at. I don't know, I can't represent to this court that I'm aware of a specific meeting where they went in front of the public and said, we're going to talk about whether we want to enter this agreement. What they did was they assigned 2 members to the rest of the river committee, and those members were who were there for the process, a long process, like a year-long process of discussing what was really being proposed at that time, whether it was a threat or whether it was real, and it certainly seemed real with the winning on appeal, is 2 dumps in Lee and a dump in Great Barrington. So that's when those 2 members representing each respective town, they ended up negotiating that agreement, and that was how it ended up coming back to the board. Those meetings of the rest of the river committee are open meetings. That's a quasi-public board. But I cannot tell you whether all of those were done in open session. I just don't have that detail in front of me right now.
So, I want to ask about the 2 sentences of 43-2. The first one talks about the selectmen may, at their discretion, compromise or settle any claim which doesn't require payment by the town of an amount in excess of $1,000. The second sentence says no settlement of a claim or suit obligating the town in an amount in excess of $1,000. Does the phrase obligating the town in an amount in excess of $1,000 mean something different than payment by the town of an amount in excess of $1,000?
No, Your Honor, and the reason being is...
Why didn't the town meeting, when it adopted these in 1971, I guess, use the same word in both places?
To read that to require the town to come before the legislative body for any inchoate obligation that's arguably something more than $1,000 coming out of the treasury of the town would require divining something that this bylaw, it would make the bylaw nonsensical, because what the town is saying there is, we don't want you cutting a check for more than $1,000 unless you come back to the town. That's the only way to read it to make it make sense. Otherwise...
It wouldn't include donating a piece of property or donating some other item of value?
That is dealt with another statute,
Okay.
Your Honor. It's General Laws, Chapter 40, Section 3. The town, and 30A, Section 30B, I'm sorry. General Laws, Chapter 30B, Section 16 requires a town meeting vote to dispose of property, and even an easement by the town requires a vote under Chapter 40, Section 3.
But this wasn't town property, if I...
This is not town property. This is Lane Construction's property. They sold it to GE. It's private property. We have no control over that property.
So what does obligation mean in the second sentence?
It's tempered by the previous sentence, which is does not require payment by the town of an amount in excess of $1,000. Then the next statement says no settlement of a claim or suit obligating the town an amount in excess of $1,000. Those 2 sentences I would submit to the court should be read together. I don't think that the intent of the bylaw is to create 2 different propositions there.
Let's take out the second sentence
Yep.
for a second. How is it any different if you take out the second sentence? says the town cannot require payment in an amount in excess of $1,000. That's all it says. It doesn't have the second sentence. So how is it any different?
Because the second sentence actually tells the board what it's going to need to get, which is a town meeting vote.
Okay.
If there could be any number of things. They could have to go to the finance committee for the reserve fund. There could be any number of stopgaps that they could create. But the second sentence tells the board where it needs to go for the 1,000 if it gets to that point where they actually have to get more than $1,000.
Well, let's assume that obligation does mean something broader than payment. It clearly, I think, refers to some kind of legal obligation, if it means something.
Understood.
So what legal obligations has the town undertaken here in this agreement that are in excess of $1,000 or could be valued in excess of $1,000? Is the town obliged to take remedial steps if PCBs are escaped from the landfill? What is the town obligated to do?
The town is obligated to do nothing that obligates the town for $5, not much less $1,000. The town is not doing anything other than not appealing. That's the one obligation specified in the agreement, is that the town of Lee would not appeal the permit that was being contemplated. And it's another important facet here is that the permit had not been issued yet, which all bets were off if the permit was issued. None of the towns had signed on to it. If not all the towns signed on to it, all bets were off.
Okay. So, I mean, it certainly could be argued that the town government or the town would have a moral obligation of some sort, or a kind of a public policy obligation to take some kind of steps if the landfill is constructed and the PCBs, either cause damage or harm to surrounding properties or to people in the town. Can those qualify as obligations under the bylaw?
Those obligations I would presume that what has been permitted here is going to cause that. It would be, that is a fact that the EPA itself, whether it has wisely done so or not, has determined in the negative that this can be done safely. There are many arguments, arguably really good arguments, that is the wrong decision. But that is not something the town of Lee has the ability to countermand. It's a permit on being treated. It was treated as a circular permit, basically to tie the town's hands and the state's, so that the DEP and the town of Lee were crippled in their ability to do anything about this dump. And that's the posture that the town went into these assessments with. Not a good position to be in. And from there, whether the town of Lee made a good decision or a bad decision, that's easy to assess after the fact, but there were some stark realities facing the town at the time.
All right, thank you. We understand this is a very important matter to the town and the citizens of the town, and we will give it every consideration. Thank you. I'm sorry, we don't allow rebuttal here. If there's something critical you think that needs to be said, you can submit a 22C letter under the Rules of Appellate Procedure, and the town may respond to it if the town would like. All right, thank you.